Item 27.
Lord, item 27 reflects, my Lord, a very shocking state of pattern emerging. This is one incident. Lord, I have narrated in past also, whenever statutory authorities exercising statutory powers of investigation goes there, Lord, the Honorable Chief Minister barges into the premises of the, wherever, my Lord, this is conducted.
How is this maintainable?
I'll, my Lord, come to that. Lord, the officers, my Lord, Director General of Police, the Commissioner of Police, they accompany her, they are accomplices, they, my Lord, abate the offense, and thereafter, my Lord, I'll place on record, I have prepared it, my Lord, they sit on dharna, the uniformed service officers sit on dharna with political leaders, my Lord. Now, my Lord, on maintainability. My Lord, maintainability, there are two petitions, my Lord, one by the Enforcement Directorate and another Enforcement Directorate along with one officer, my Lord, who is personally agreed. He is a citizen of India. And, my Lord, there is a second petition by two individual officers.
28.
Yes, my Lord. And I have, my Lord, narrated earlier incident also where Joint Director CBI's house was ransacked, my Lord. It was garrowed by people, my Lord, stones were pelted. He was giving, my Lord, frantic calls to survive him, to my Lord,
Yes.
here, my Lord, there was an evidence leading to, my Lord, a conclusion that there is some incriminating material lying in one premises of a company and premises of one individual. My Lord, the officers exercising powers under section 17 of PMLA goes there. They intimate the local police that we are going there. The Honorable Chief Minister, who is joined as a party, along with the Director General of Police, along with the Commissioner of Police, along with the DCP of the area, and large police force, goes there, barges into the house. Whatever material was collected was taken over unauthorizedly, which according to me, my Lord, I have not hidden anything, and I am not feeling shy of saying it's an offense of theft. It's an offense of, there are several offenses, my Lord, which I have mentioned. She takes it away, including, my Lord, one of the mobile phones of ED officials. And, my Lord, thereafter, there is no question of, my Lord, my proving it. The respondent number 2 goes before the media and says that this is the great thing I have done. Lord, if this is, my Lord, turning a blind eye to, Lord, this kind of things will continue, which will encourage not only the people in public life, it will encourage the officials, my Lord, to not discharge their duty. They would, the central forces will be demoralized and the state forces will feel that, yes, we can go with the Chief Minister, we barge into somebody's premises, we collect the evidence, we commit theft of the evidence, and thereafter, if needed, we will sit on dharna also along with the Chief Minister. So, my Lord, I am moving an application seeking a specific prayer that let that example be set, that the officers who were admittedly present, my Lord, during our exercise of powers under section 17 be placed under suspension, and, my Lord, let there be, my Lord, a departmental inquiry, because this is a serious misconduct, even department.
So you want us to suspend?
My Lord, your Lordship may direct the competent authority to suspend. That's the prayer. Now, my Lord, we approach the High Court. Please see, my Lord, what happened in the High Court. My Lord, page 1.
There is no such IE. We have not read.
No, my Lord, it is filed e-file. Lord, I have the copy, my Lord. They are served.
Served at 8 o'clock in the morning.
Yes, yes, it is served, my Lord. It is served late.
I'm not disputing that.
I'm not saying it is served. It is served late,
Yes, yes.
but it is, my Lord, filed. Please see, my Lord, my prayer. Lord, this is something very, very serious, your Lord.
Yes.
May please take, my Lord, cognizance of what is happening. Lord, first, see, I have quoted section 54 in my Lord, context of the officers. Section 54 at page 5. Your Lordship gets, my Lord, page 5.
Yes.
My Lord, this is PMLA Act, section 54. Certain officers and others to assist in inquiry, etc. The following officers are hereby empowered and required to assist the authorities in the enforcement of this act. One of them is officers of the police. And here police comes along with the chief minister to ensure that the evidence collected is removed by them under their supervision, under that threat. Please have a look at the prayer. Prayer on the same page. Pass an order or direction placing under suspension the respondent number 3, 4, and 5 and any other police officer present during the raid conducted by the Enforcement Directorate on 8th of January 26. Direct the newly implemented respondent number 7 to 9. That is, the Chief Secretary and their cattle controlling authorities, which I am seeking to implement, to initiate departmental inquiry proceedings for major penalty. But right now, we are concerned, the pattern is this. I have given the examples and I'll take your lordships to those examples, shocking examples. Earlier the CBI officers go. They do not go on their own. There is a judicial order passed by this honorable court directing investigation into some cheat fund offences. There is a discharge of their duty. The police officers are, the CBI officers are arrested and taken to the police station. The chief minister comes at the residence of the then police commissioner, who happens to be the director general of police today, and stages a dharna on the gate so that nobody can enter. The CBI officials, armed with the order of this court under an obligation to investigate in a different offense, are not permitted to do that. There are there was a bail application, and I'm placing those pleadings on record. There was a bail application of the law minister of the state being, one of the accused, a very prominent leader. The sitting law minister goes inside the courtroom and sits there with a crowd of 5,000 people shouting slogans. So there are several things, we want to shoot. Even in this case, this is the position. And another thing, kindly, appreciate.
Yes, 1 minute.
Yes. Kindly see what happened in this particular case. Please come to page 121. We approach the Honorable High Court. Page 121 may be seen. This is what happens when mobocracy replaces democracy. 121. This is what the Honorable Judge of the High Court records in a judicial order passed. The matter is taken up for consideration. At this juncture, a huge number of learned advocates as well as other persons enter the courtroom and create enormous disturbance and commotion. The request made by the court to maintain the decorum and dignity of the court so as that the matter can be taken up for consideration fell on deaf ears. The environment in the court is not conducive to commence or continue with the hearing. In view of such situation, the court says it's not conducive for hearing. In view of such situation, this court is constrained to adjourn the matter. Let the matter appear under the heading new motion on so and so.
Yesterday.
No, my lord, this was earlier. Now, my lord, your lordships, our innocent guess would.
9th, Malaj, 9th.
It's
Yesterday
9th.
the hearing
It's
took place,
9th.
there was no ruckus.
Yes, yes.
Yesterday the
I
hearing.
found out what happened. I was
I was
there.
there. I was there. I saw what happened.
You should not have been there.
Deliberately.
Why should I have been there?
I was
Why should I have
prevented
been
from speaking. My mic
I
was
saw it.
Only a
It is
minute,
on
only a
video.
No.
It is on video. I saw the video later in the day.
My learned friend.
Here itself.
Yes, exactly.
Yes, my lord, my learned friend vehemence.
Let him.
Lord, I understand.
Your
Lord, yeah, our
Don't put any ruckus here, please continue.
no, my lord,
Continue, please.
our my lord, innocent thinking can be after reading the judicial order of the learned judge that maybe because of the sensitivity of the matter, the lawyers may have gone, some people, other people also may have gone out of curiosity and that might have resulted into an unintentional kind of a chaos and chaotic situation. I have placed on record the WhatsApp chats that the Lord, the law wing of the party in power, my lord, of which the chief
No, it's
minister.
intentional or unintentional, but the High Court has recorded something.
Yes, my lord. And this was not, my lord, this was not spontaneous. My lord, they were all instructed by the legal cell of the parties to go there. That is page 119, my lord. This is, my lord, the WhatsApp message, my lord, one of the WhatsApp message from the legal cell of the party, my lord. Today on 9th January, court number 5, item 10. Come everyone. Lord, he is convener, Mr. Amit Kumar Das, convener, High Court. Then, my lord, second, gathering today at 1 p.m. at B gate.
Come everyone, as if it is Jantar Mantar.
Yes, the court is converted into Jantar Mantar. Lord, kindly read the second part. Today 9-1 is the first. Lord, today 9-1-26, court number 5, item number 10, come everyone. Lord, this matter, which learned judge records on 9-1, which your lordships have read at page 121. Next, gathering today at 1 p.m. at B gate, come everyone, will go to the procession of the Honorable CM so-and-so. Bus and vehicles are arranged. This is the, my lord, preparation. Yesterday, my lord, the Trinamool Congress, the party in power, filed a petition. In that, before the petition comes for hearing, look at the position in the High Court. The Honorable Acting Chief Justice then had to pass an order that nobody will be permitted to enter in this courtroom except the lawyers appearing, and it will be live telecast. It was only because of that, my lord, precaution that some hearing took place. That also, my lord, was less than, my lord, satisfactory. My learned my lord, senior friend appeared, and my lord, we faced several difficulties. I don't wish to say that, my lord. Here, if needed, we'll file even an affidavit. His mic was being constantly muted. Lord, these are, my lord, the issues. Your lordship,
No, but
kindly.
it is in the control of the court.
Lord, Lord, I don't wish to go into it, my lord. This is a petition for seeking protection of my fundamental rights. We are officers. My lord, the ED is not an organization only. My lord, under section 7 and 8, whatever, my lord, we recover, we don't recover for our personal purposes.
What is he handed over?
But it is this
Lord,
instructions issued by the court.
yes, my lord. Lord, this is something very rare. Even the Honorable Chief Justice is aware that it otherwise cannot be, matter cannot be heard. This is the position, my lord. Now, please see, my lord, the act. What is ED, my lord, on the maintainability? Let me satisfy your lordships. Lord, please come to page, section 8 of the PMLA. Lord, what is the role of ED in the scheme of the PMLA Act? No, it's not just an organ, merely an organ of the union government. Lord, we exist for this purpose. That's what, my lord, I'm trying to show.
Subsection 8 of it.
My lord, section 8, your lordships have?
Yes.
My lord, adjudication. Please come to subsection 8 now. Now, my lord, we do everything. We, my lord, attach the property, we take the property in our possession, thereafter confiscation proceedings, etc. Ultimately, what? Who is the ultimate beneficiary? Please see section 8. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offense of money laundering.
Subsection?
8, subsection 8 of section 8.
Yes, yes.
I read again, my lord, for your lordship's convenience. My lord, we go far through.
Where a property stands.
My lord, first is attachment, thereafter, my lord, taking possession. All, my lord, there are some provisions for appeal, etc. But eventually, when it is confiscated, my lord, this is what happens. The victim gets the benefit of this laundered money. That's what I want to show. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offense of money laundering. Now, my lords, what we do, my lord, just to give an example, so that I'm showing my, my lord, locus to approach your lordships. Because I represent, my lord, those victims. My lord, suppose I am investigating money laundering in a bank. The bank goes in, my lord, liquidation or something happens, my lord, to the depositors. My lord, this amount which we collect will go to those depositors. My lord, the ED has so far, my lord, collected more than 30,000 crores and which are given to the victims of the crime. So we are not just an organization. My lord, we represent the will or, my lord, the interest, not if not the will, of those victims of the offense to safeguard their interest. But, my lord, petitioner number 1 is the enforcement directorate. Petitioner number 2 is an individual officer. My lord, we are now, what they do is, there are 3 FIRs filed against us by 2 by the Honorable Chief Minister, 1 by the police against us, that we did something illegal, we browbeated them, etc., etc. Based on, and this is something very shocking, based on that FIR, they came to the scene of the offense which they committed and removed the CCTV footage.
So what for you went there? And what,
Under section 17 for seizure, for Manoj, kindly see,
No.
search and seizure.
what was under investigation?
Yes, Manoj, please come to,
Page B.
please come to, Manoj, page B, second para.
Page?
B. B for Bombay.
B for Bombay, Manoj, my synopsis. Manoj, they say that we went for collecting SIR data, Manoj. A fool will not go to collect SIR data, which is available on the website. B. The petitioners are constrained to approach this honorable court under the most extraordinary, unusual, and unfortunate circumstances emerging from the petitioner. As pointed out in detail hereunder, the petitioner is investigating a multi-state money laundering offense under which the proceeds of crime to the tune of rupees 2742 of 0.32 crores are derived from the illegal coal mining.
This offense, this particular scam is being investigated.
Yes, by us, my lord.
And for this you went inside.
Yes, my lord. Now, please oblige me by coming to page 5. Page 5. This offense is being investigated. Page 5, para 5. Para 5. Page 5, para 5 at the foot. During investigation, it was gathered that the illegally excavated and stolen coal used to be sold in Shakambari group of companies. On analysis of the documents seized from the premises of so-and-so, so-and-so, and so-and-so, it is revealed that so-and-so group used to receive cash from so-and-so group against sale of illegal excavated coal. So-and-so group of companies are primarily into steel manufacturing. The group is led by so-and-so, who is the managing director of so-and-so limited and is also director in other group companies. From the evidence collected by the petitioner, it is evident that coal used to be purchased by so-and-so group of companies owned and controlled by so-and-so from coal syndicate led by so-and-so. The payment for the coal used to be made in cash. The so-and-so has not complied with the summons issued for recording his statement under section 50 PMLA. The act of purchasing illegally excavated coal from so-and-so constitutes offense of money laundering in the hands of so-and-so and so-and-so. It was therefore proposed that residents of so-and-so and corporate office of Shakambari Group be searched under section 17 as they have committed an act which constitute money laundering and are in possession of records relating to the offense of money laundering. Further investigation regarding the utilization of proceeds of crime was undertaken, which revealed that the proceeds of crime generated from coal sales were utilized by sending the proceeds of crime through both domestic and international Hawala. One such Hawala operator used by coal syndicate to transfer proceeds of crime has been identified from WhatsApp chats of so-and-so Hawala firm named so-and-so was used for Hawala transfers by the coal syndicate as seen from the WhatsApp chats. Intelligence was received that around 20 crores of proceeds of crime from Kolkata to Goa was transferred through so-and-so firm. The employee who handled the Hawala transfer at so-and-so is so-and-so. Material evidence has been gathered which disclosed that 20 crores of proceeds of crime arising from illegal coal mining were used through interstate Hawala networks layered through a chain of felicitations, converted into cash at Goa and channeled into, now please see, IPAC. This is
Not felicitation, it is facilitated.
facilitation. I'm sorry. It means the meaning changes drastically. I stand corrected. My apologies. IPAC's operational framework. This is IPAC where we went for search under section 17 of the Act. Operational framework by being handed over to persons executing its work. Thus, the search proceedings were started at 10 different premises situated in Delhi and Kolkata on 8th January 26. Out of the said 10 premises, one of the premises was
Same IPAC with which earlier Mr. Prashant Kishore was associated?
Yes. 10 premises. One of the premises was the residence of Mr. Pratik Jain, situated at so-and-so, Calcutta. Sri so-and-so assistant director was authorized by Sri Bansal, deputy director, with the authorization number so-and-so to carry out the search and seizure proceedings at the said residential premises of Mr. Pratik Jain under section 17 PMLA. During the course of such proceedings at the office premises of Messrs. Indian PAC Consulting Private Limited and the residence premises of Mr. Jain, certain police personnel has arrived at their respective premises and asked the officers conducting the search to intimate a local police station if they wanted to continue their search. During the course of the search at the residential premises of Mr. Pratik Jain,
This authorization the officers were possessed of.
yes, my lord, we showed they gone. As a matter of fact, we intimated them in advance by mail. Even on that day, it was shown.
To the person in charge of the premises.
Premises also that this is the authority under which we are coming, and we are not interested in any of your political activities, if any. We are confining only to this, my lord. But I do not know what was there to hide that such a drastic step has to be taken that the Chief Minister herself personally barges into it, along with the Director General of Police and Commissioner of Police and DCP and the entire police force. Then, my lord, further, during the course of the search at a residential premises of Mr. Pratik Jain, situated at so-and-so on 8/1/2026, various digital devices were taken into possession which were suspected to be relevant to the PMLA investigation. During the course of such search at around 11:15 a.m., Sri so-and-so, Deputy Commissioner of Police South Kolkata, visited the building premises and informed the authorized officer that a complaint of house trespass has been received by the police. Thereafter, for the verification of correct facts about the proceedings, the DCP was shown the identity cards of the team and the search authorization letter. Thereafter, Sri Manoj Kumar Verma, IPS, the Commissioner of Police Kolkata, also entered the premises. As the police officers were being briefed about the search proceedings under section 17 PMLA at around 12:05 p.m., Miss So-and-so, sitting Honorable Chief Minister of the West Bengal, duly identified, entered the premises despite making categorical requests for not interfering with ongoing search proceedings under PMLA. However, violating all law and order, Miss So-and-so, with the aids of police, forcibly took possession of all digital devices and incriminating document from the possession of authorized officer, Sri so-and-so, Assistant Director, and left, he is the petitioner before your lordship, and left the premises at around 12:15 p.m. All the proceedings have been recorded in Panchanama, duly drawn at the premises on 8/1/26. An incident report dated so-and-so was also drawn at the said premises by the authorized officer who was conducting the search. Lord, please see the totality of this. Section 17 authorizes the search. The person searching has the authority later. The people who come, my lord, the DG, police commissioner, everyone is shown those things. That these are our identity cards. This is our authority later under the statute. And they have, my lord, this, Lord, I'll not use any adjective, my lord, but courage to take the incriminating material in their custody, which is a theft, go and my lord, thereafter publicly declare that this is what we have done. And this is not the first time this has happened. My lord, kindly take this, my lord, so that once and for all, my lord, this is decided. And my lord, IPAC, whose premises is search, has not filed any complaint
Or even petition.
or any proceedings that my privacy was invaded, etc. He could not have, because it's a statutory search under section 17, but he has no complaint. But everyone, my lord, is fighting. Yesterday, my lord, there was a petition filed by the party, the Trinamool Congress. And my learned senior friend, my lord, appeared, Mr. Raju, and he said,
What are these photographs we have filed?
Yes.
yes, for staging of dharna, etc. Surrounded by the officers, my lord, which they ought not to have been there.
Is this incident or some other incident?
This incident. These are the colored photographs, my lord. You are not placed colored photographs. I undertake to place colored photographs on record.
There is some
Kindly have
color,
colored photographs.
some color, some black and white.
No, my lord. My apologies, my lord.
No, there are colored also.
Yes, my lord. These are this incident.
81, 82, 83 is colored.
In a lighter vein, Millet, some truth is colored and some is in black and white.
In fact,
There is nothing in lighter vein.
Light vein. In a lighter.
This is everything very, very serious.
Smile.
I'm
I need to respond. Don't have to hang.
smiling, but unfortunately, it's
Answer all what you have said.
we listen notice, Mr. Sibal, this is very serious matter.
yes.
We have to examine this.
I'm sorry?
Sorry, mic was off.
Yeah.
We are issuing notice
Yeah.
and we want to examine this. This is a very
No, no,
serious
I mean,
matter.
We have, your lordships will hear us, Mullahs, before doing that.
Yes, please.
Yes, Mullahs. I just want to, Mullahs, let me first clear the air, Mullahs.
Yes.
Mullahs, who is IPAC? And I'm sure they know about it. Mullahs.
No, I'm sorry, just because there are two.
I'm appearing for respondent number 2,
And I'm
who
for
is
one
the
and
chairman of the Trinamool Congress.
I'm for one.
Right,
and three,
the chief
state
minister.
and the police department.
Happens to be the chief minister.
Happens to be, yes,
Yes.
but I'm appearing as
Yes.
chairman of the.
Chairman is never
If you don't, please, I did not
only a
interrupt you,
minute.
sir.
Only a minute. When you say
I
chairman,
did not.
chairman of a party
do
is
not-
never accompanied by the director general of police.
Allow me, sir, to argue
Please,
before.
my learned will not decide whom we are appearing for with great respect. How will he decide that?
Mr. SG, please allow them to argue.
No, certainly.
Allow us to argue.
No, I didn't know who appears for whom. Therefore,
Yesterday, this has been done by your.
yes.
But that's, we'll come to the issue, according to me, is maintainability. Your lordships will have to decide that the High Court cannot hear this petition for reasons that I'm sure your lordships will give. And if the High Court can hear this petition, then why should your lordships hear it?
No, we are very much disturbed with the way High Court has been almost
No, the hearing took place yesterday, Mullahs.
yesterday, but
Yes.
what happened? on
Yesterday,
But
9th?
that's not going to be repeated.
Keep-
That's not going to be repeated, Mullahs. The question doesn't arise. If it took place yesterday, it will take place tomorrow also.
That is my learned friend.
So your lordships will have to now assume that the High Court can't deliver justice. Fine, but I'm not saying don't. But Mullahs, your lordships will have to say that, Mullahs.
You cannot put words into our mouth.
No, I'll say your lordship.
Assume and what we will not
No,
assume
if your
is our
lordship-
business.
Of course,
Mr. Sibal.
of course. But I'm not saying, Mullahs, your lordships.
Please argue your case.
I'm going to argue, Mullahs.
What we will do.
My argument at the initial
Please-
stage is
please proceed
that
with your argument.
this matter should be heard by the High Court. Because the High Court is the court which has the 226 jurisdiction. It will hear the matter, render findings on the basis of whatever they are arguing there, Mullahs. We have a right to appeal, and then we can come to this court. That's the hierarchy of courts, Mullahs. And they are now filing parallel proceedings, not wanting to go to the High Court. And their argument is on the last day, that on the 9th of January, there was a ruckus, and therefore proceedings could not take place, which is correct. And then on 13th of January, the Chief Justice passed this order, and then yesterday a hearing took place, and the hearing was peaceful, Maharaj. There is nothing to assume that the hearing cannot take place, Maharaj. That's point number one.
Yesterday, Mr. Mehta's client sought time, saying that we have filed in Supreme Court.
Yes, yes.
High Court, can I finish, please, sir? So the High Court said, we are adjourning it sine die with liberty to come back the moment you think the Supreme Court is over, etc. So yesterday, without any ruckus or any involvement, they sought adjournment specifically on the statement, which is why the yesterday order was passed. That's only a fact which should be noted by your lordship, and they said that the matter is coming today.
Correct. Now, Maharaj, on the contentions on facts that he has made.
Yes.
Maharaj, IPAC, we all know, Maharaj, is an entity which takes care of the elections in West Bengal. A formal contract has been entered into by the party with IPAC way back in 2021. And I assume, Maharaj, that the ED knows about it.
No, elections in West Bengal are conducted by IPAC or by the election?
No,
Commission?
all the material, there's a confidential material for the purposes of this agreement. Confidential information shall mean any and all information, including but not limited to sensitive or non-public information of any nature whatsoever. There's a whole series of data, of documents, of information, of facts. All that is confidential and it is kept there. And I'm sure that the ED knows about it. He knows about it. So when they went there, they knew that there's going to be a lot of information in respect of the party, the candidates, what is happening, what is the program, where we're going to go, what we're going to do. I'm sure they knew about it. So, Maharaj, the first question that arises is, why was the need to go there in the midst of an election? Why was the need to go there in the midst of an election?
Yeah.
Now, Maharaj, in the coal scam that we are talking about, Maharaj, the last statement in the coal scam was recorded on the 24th of February. 24th of February, 2024. What were they doing in 2024? What were they doing in 2025? And why were they so keen in the midst of an election in 2026? And we're saying we want for what? SIR for what? It is all the information that's in the computer. Once you get possession of that information, how are we going to fight the election? So, Maharaj, which is why the chairman, Maharaj, the chairman has the right to go. It's the property of the party. So the chairman then went, because they went to the house of IPAC, the individual Pratik Jain, in the morning, in the morning, at 6:20 in the morning.
Yes.
ED went at 6:20. Chief Minister only came at 12 o'clock, Maharaj, and went away at about 12:15.
They collected everything in it.
One. Maharaj, this is, you can make any statement you want to make, Maharaj. There is a provision in the BNSS which says that kindly 105. And the lies will be demonstrated if they show the video. Take 105 of BNSS. We're also very disturbed, Maharaj. Extremely disturbed as to what is happening. Why should ED, Maharaj, wait for 2 years to come to West Bengal and go to an office which is a party office, which has all the data with all the information? It's part of party office. Kindly see 105. The process of conducting search of a place or taking possession of any property, article or thing under this chapter, or under 185, including preparation of the list of all things seized in the course of such search and seizure, and signing of such list by witnesses, shall be recorded through an audio-video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate. Please show that recording. Everything that is in the statement will be proved to be a lie. That respondent number 2 took all the devices. It's an absolute lie. And it's contradicted by their own Panchnama in this petition. I read the Panchman out to you. This is very unfortunate, Mullahs. And that's why, in a matter of this nature, Mullahs, and I'll come to the law a little later, Mullahs. This is just to create prejudice. Now kindly come to the Panchnama. 66, Mullahs. I'm going to show you. Page 66. Mullahs, kindly come to 66. We above named Panchas, your lordship sees that? And kindly come, they show that, search was conducted. Now kindly come to 68. Yes, kindly see. During the course of the search, so-and-so inquired about the ongoing proceedings. At 12:05, Mullahs, search started in the morning. No seizure took place. Till 12:05, no seizure took place. And inquired about the ongoing proceedings, informed her about the proceedings. At around 12:15, took possession of material being seized via laptop belonging to Pratik Jain. Now, laptop belonging to Pratik Jain will have all the information about the election. Every piece of information. Several documents and iPhone Pro belonging to Shri Pratik Jain have left the premises. Several documents. Where are all the devices? He just read in the petition that she took away all the devices. Contradicted by their own Panchnama. An iPhone. She took the laptop which would have the party information and she took their personal iPhone. That's all, nothing more. And then see for third paragraph. The search was proceedings commenced at 6:20 on 8/1/26 and concluded at 2:50 on the same day. The search was conducted in a peaceful and orderly manner. And no damage to any person or property was caused during the search. The entire proceedings were conducted in the presence of the lady staff and anyway, whatever. There was no obstruction. And signed by ED. So where is the averment in the petition is contradicted by their own Panchnama. Now, Mullahs, what's interesting is there's another Panchnama at 73. Because then they go, Mullahs, to the other office, which is at Salt Lake.
Another party office.
It has party material, election material, which you are aware of, which is why you went there. It is a completely mala fide act on the part of the ED to disturb the process of election and to gather as much material as they can from the office, which has all the material, which is through a contract, which contains all the confidential material. Now kindly come to see the second Panchnama. 74 bottom. During the search proceedings, Ishant Taneja, Pavan Verma, so-and-so, and other employees joined the search proceedings. They were also explained the purpose of the visit by the authorized officer. Meanwhile, Shri so-and-so, so-and-so joined the search proceedings. He also offered personal search. Officers started the search proceedings in our presence in a peaceful manner. Nothing was seized. Nothing was seized there. Nothing was seized here. From the premises, and no data backup was taken by the team of Director of Enforcement. And the search proceedings concluded at 6:45 p.m. on 8/1. Documents available in the different sections of the premises were not mingled with each other, and the same was left in a proper and orderly manner. These facts were duly acknowledged. That's it.
Contrary to what you are submitting.
I'm sorry?
They had the intention to collect materials from your party office. They would have seized from
They were
you.
just photographing.
They didn't seize anything.
They don't have to seize it. They can
They didn't
photograph.
seize anything.
They can photograph it. They don't have to seize it. But your lordship
Their
knows.
Panchnama says they have not recovered anything. If they had
Well, why did they-
any intention
Mullahs, what?
of seizing your material belonging to your party,
Mullahs,
they would have seized.
we are not discussing.
They have not seized.
Mullahs, these are facts which will have to discover, which will have to be dealt with, Mullahs, in a writ petition.
We have to examine.
Mullah,
You file counter, we'll examine.
no, Mullahs,
You cannot restrain us from issuing notice.
I'm sorry, of course I can't, Mullahs. I can persuade your lordship, that's all. That's what I'm trying to do, Mullahs.
Yes, please.
I'm only trying to show you
Yes,
the Panchnamas certainly demonstrate that there was no untoward things that happened, both at the residence of Jain as well as in the office of IPAC. Kindly have a look. So the Panchas, Malas, and the Panchnama doesn't say anything of that sort, Malas?
Yes, yes.
Right. Now, the other question, one question is, Malas, and I told your lordships on 24th February 2024, Malas, the last statement in this coal scam was recorded.
Yes, yes.
Then why was the need to go in
That's wrong,
2026?
factually wrong.
I have got it. I've got it here. Why do you say it's factually wrong?
From
That's
the record
here.
of the investigation.
No, we have it.
Last instance.
We have it here. 23rd
Because
of February.
we are conducting the
23rd of February,
No better.
you have given these details to us. Your petition, you say that 23rd February, Mukesh Thakur claims he transferred the money to Goa at the request of Jitendra Mehta, a financier of Aks. That's it. After that, no statement. It's your petition.
That is at page.
Para 12 itself, page 104.
We don't.
Just read it.
All evidence at this stage, my lord.
Ari,
The
you
last
have
statement
your,
is
I'm
recorded
taking
in
your petition.
December 24.
Again, you are interfering. I'm taking your petition.
Sir, come pages. Eight.
But kindly come to page 8.
Page is.
F.
Page F.
Yes.
Is.
S.
Yes.
Okay, I'm sorry.
Yes. Which one you are?
Whatever you give me.
Director of Information.
Yes, you give me.
1 July 2020.
CBI furnished CBI furnished the second supplementary charge sheet in the proceedings emanated from FIR on 1/7/2024.
Last date, 8/1/26. Concrete material found during investigation.
That's right. So that's precisely the case. That from
January
2020,
26.
that means 2024, what you were doing nothing, suddenly in 2026 you find material?
On the lighter event, what Mr. Tushar Mehta is suggesting, if money is laundered only during the election, what is their fault?
There is no election, my lord.
That's why this relates to
on a
Goa.
premise that ongoing election. Which election?
Solicitor, you are such a good person.
I-
Have the patience to hear us.
My learned friend disarms me.
Well, you're right. There is no election in Goa.
This is not Goa, this is Bengal.
No, this is where Goa, money transfer to Goa.
My learned friend said during election, why did you
During
go for
election
search?
in West Bengal.
There is no election in West Bengal.
Oh, I see. Well, if this is the level of knowledge, Maharaj, that emanates from the solicitor, there's nothing I can say, Maharaj, that there is no election in West Bengal. I'm sure it does.
He's yet to be notified what he's saying.
Yes.
He can say that, Maharaj.
Huh?
He's a very precise lawyer. He's very careful with his words.
I am, my lord. Therefore, I am saying there is no election. Your
There is-
premise is wrong.
Absolutely, there will be
And
none.
my lord, only one line, my lord.
There will
Allow
be
me
none.
to interrupt.
Allow me,
My lord, if the ED officials go to
Can I
their
argue
party
with
office,
this?
it's not a party office,
Can I argue with
it's an
this?
office of a strategist kind of according to them.
No,
What
Maharaj,
would a normal person do? Please give me a minute.
can you? No.
These documents
One second.
have two sets.
One second. let me-
One, my party thinks, and another maybe else.
One second. wait.
Another you can go, but allow me to take my party
Yes.
details.
This-
You have nothing to do with this party
The
details.
solicitor seems to have.
Just takes everything which is shown in the media with files and everything, that I have taken everything. Otherwise, but if there is a scrutiny, say, no, this is my party
Everything
document.
that he says has to be accepted, no, then why are we here? Merely because he keeps on interfering, says what he wants to say, as if, Malas, this is the gospel truth. It's not fair. It's not fair on us. Now, Malas, kindly see page 38.
1 minute. I'm there in the second petition.
But
No,
you
one
have to
second.
finish
Let
it. Let the
finish that. Allow us
correspondent
to
argue
finish.
at least
Stage
2
of
minutes.
recording of
Allow us to
evidence.
finish.
It was not to be seen.
Now, Malas,
By ever-
Correspondent argue
ever
2 minutes at
been
least.
We are arguing only first petition.
Very well.
I'm arguing only the first page. Now, kindly see page 38.
Petition you will be allowed to argue.
The second is,
Don't worry.
yes.
Kindly see page 38, Malas. Kindly see page 38.
38.
Yes.
You see, there is some circular issued by the Honorable Chief Justice about time schedule.
Yes, yes. You must
Should
fix it.
apply to
Yes, and interruptions, Malas, both.
motion hearing also.
Both
Not
hearing.
to regular hearing.
The moment.
Yes, but the Honorable Chief Justice also should
Apply to.
issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences. That is also.
That also, Malas, that the CBI should not be leaking information and
Yes.
the ED should not be leaking information
Yes. No, there is no, you
surreptitiously
find,
to journalists of their liking.
I'm.
Therefore, there should be a ban on that also.
Yes, I'm ready to show, my lord, what I've stated.
You can show it.
Can
You
I-
can show it.
This is not the
Narrative
circular of-
building.
That's why
should
Malas,
also
my
be-
learned friend always, he's very upset at the fact that I do some program, Malas. He seems to mention, it's his, every matter he mentions this, Malas.
No,
You should watch
no,
it a little
I'm
more,
very
he'll
happy
understand a
with
bit. more.
programs. Don't discuss matters. Don't discuss matters which were.
I'm entitled to.
I have not seen
I'm
any.
entitled to.
No, no.
No, I'm not entitled to. Well, he knows about it. He's
Mr.
there.
Mehta is increasing the circulation of this program now significantly
No, it is.
without watching it himself.
Malas, page 38. Let's move on to the matter.
Yes, 38, 38.
Yes. Now, what are the offences, Malas, that are alleged?
Yes.
Yeah, it's all 37, but the offences are all these offences: abetment, criminal conspiracy, voluntary causing hurt to public servant. No such thing. It's on the face of it. In their own petition. Wrongful restraint. No statement of that sort. Wrongful confinement, force, criminal force. What is all this going on? 1/3 assault on criminal force, obstructing public in discharge, omission to assist public servant when bound to give assistance, disobedience to order duly promulgated, theft in dwelling house, theft after preparation made for causing death, hurt or restraint, robbery, dacoity, criminal trespass and house trespass and house breaking, house trespass in order to commit offense, causing disappearance of evidence, destruction of documents. What is all this? This is all contrary to what is in the Panchnama. How can all this happen? And Malas, all this has to be done how? Under 66(2). Under 66(2), if there is any offense, it has to be reported to the investigating agency of the state. Your Lordship knows 66(2). I'll read it to you. How can all this happen in a writ petition in the 32? Can you see 66(2)?
56.
66.
We have gone through that.
Sorry, PMLA.
PMLA. I saw
Yes,
it,
yes.
866.
Yes, no. 66(2) of PMLA. I read the offences to you just to indicate that all this cannot happen in a writ petition.
No, it has not happened in a writ petition. It has happened there.
No, he is saying these offences have been committed and therefore they have to inform under PMLA if the director or other authority, just read, Malas. If a director or other authority specified in subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being enforced, that is IPC, these are IPC offences, are contravened, then the director or such authority shall share the information with the concerned agency for necessary action, which is the state agency.
CBI investigation is.
So, Malas, so what they are saying is these offences are committed. They say now you must charge them with these offences. We have filed a writ petition, whereas under the statute they have to inform the agency of the state that such offences have been committed. Please investigate. They can't ask your Lordship in an Article 32 to do that. And they are choosing the agency which is being accused by us for mala fide searches. And then apart from all that, and I'll let my learned friend take it forward, Malas, apart from all that, Malas, the question is, why should the High Court not hear the matter? High Court is not disabled to hear the matter.
I'll take.
So we'll take our submissions.
I'll take
You've got only one
Mr.
answer.
Mehta, please allow correspondent three
I'm
minutes.
not on the merits. But one response to Mr. Sibbal, a very respected. I personally, you know, I respect him. My objection to matters of arguments being debated elsewhere is not only against Mr. Sibbal.
It's also,
Everyone
it's also against
who
me.
appear
Yes.
in
No,
the
that's-
matter
that-
should not give press conferences
My
and
learned friend, my
give
learned friend.
media interviews justifying or creating a narrative. That's in principle, not in this.
In principle, my learned friend should have no objection. In principle, he should have no objection because he knows that that's not the law. Once a judgment is delivered, it's public property. And this court has said that once it is public property, it can be discussed. And he knows the law, but he doesn't want to reveal that he knows the law.
No, my lord, the incident in question, there is no judgment in law and narrative building. is
My
going on.
learned friend is wrong. There is a.
I leave it at that.
There is a.
Now, can I, Minister?
I leave it at that.
3 minutes. I heard my lords, Minister, what my lords.
No, we have the entire, about second half bench is cancelled.
I'm in that matter, Minister. It was mentioned without telling us. That bench, Justice Amanullah and your lordship.
Sir, I do not know your boss, but your advocate on record was
But
informed
then
that he
let
was
me, my
present.
lord is saying something, let me
No,
respond
council
to
has
my lords.
He was
requested,
present.
it was cancelled by the bench, by the
I see.
court, not by the any
I was
request of
told
any.
somebody mentioned it, he told us after.
No, my lord, we
Anyway.
mentioned with presence of his advocate on record,
Anyway,
with consent.
What Mr. Singhvi
I
said.
can apologize.
in fact, the court said that we'll
what
fix a
Mr.
date
Singhvi
later.
said, he should have been heard before cancelling the bench.
No, I should know it.
Understand why?
Yes.
They have long
Lord, he
conferences
can-
that they do and they should
Understand
put
why
Can
it
be
in.
deemed as having been heard, my lord, for all purposes.
Anyway, with this,
So in that bench,
all these
that
digressions.
bench he
let me
says,
come.
2 PM bench, that he should have been.
I know
heard
Justice
before
Amanullah's
cancelling the
bench.
bench,
Anyway,
so that it should have been
Let it
recorded
come
in the
down.
order sheet that he has heard. Yes, next. Please, please.
because those people come and have long conferences, discuss matters, and suddenly they mention without telling us. That's why I was
Yes, yes,
complaining.
yes, you are right.
Anyway, brothers.
You are right.
Now I'm going to make 3 or 4 points in less than 2 or 3 minutes, brothers. One is we have serious objections to the maintainability of this so-called Article 32. In the highly unlikely event that your lordship issues notice, your lordship should make it clear as a caveat that it is subject to a very strong preliminary objection on maintainability, which shall be alive.
Yes.
There are judgments which say that an ED or a statutory body like the ED coming straight into a walk-in system of 32 requires very grave consideration. It is allowed in exceptional circumstances where, Malas, it is necessary that the ED is virtually remediless. That's the test. That's point number 1. I propose to raise it, Malas, strongly, both today and in any eventual hearing.
You are agreeing for state of.
I am
West
for
Bengal.
1 and 3, state and
State of
police,
West Bengal.
state and DGP. 1 and 3, he's for 2. Point number 2, Malas. I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law, because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship will take my word for it. The prayers are virtually identical
We are in High Court and
in
here.
High Court and here. Lordship need not waste time seeing it. Lordship will take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel riding 2 horses.
Why should it happen at
No,
all?
Malas, that's a different issue. We'll answer that. I understand my lord's concern. And don't think I don't appreciate my lord's concern. I don't think any of us hold a brief that should.
Today it is this High Court, tomorrow the.
No,
some
Malas,
other High Court.
sometimes Malas, emotions go out of hand and they can't be controlled. That, Malas, please don't misunderstand me that I'm not understanding my lord's concern. And that, Malas, I don't think anybody will hold a brief. Perhaps, Malas, emotions go out of hand and we are not able to control. But the relevant test is yesterday.
No, you see, emotions
Yes.
should not go out of hand regularly.
No,
In an
it's not.
orchestrated manner.
And then on 9/1, again, emotions go.
Now, Malas, may I just say? We are now, Malas, talking of R1 and R3. I am saying this, Malas, that the relevant date for considering forum shopping is yesterday. I understand. I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, please don't hear me, and the High Court is supposed to pass such an order. Anyhow, it is not that you are getting this date yesterday because of the ruckus. Kindly give a copy now. Why don't you give a copy? So, Malats, in effect, the High Court is told, I am riding two parallel horses. I am telling your Lordship I am riding two parallel horses. But you please stay your hand. And the High Court records this order, one-page order. I am adjourning it sine die. Obviously, Malats, in Committee of Courts and Superior Court and all that, Malats, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am, Malats, on the conduct. So this is forum shopping. I again take the strong preliminary objection. My third submission is, Malats, the Panchnama, which has been read. Malats, that has been read, I am not repeating it, but just note the relevant words, only the operative words, 3 lines, which Lordship has seen, Panchnama, which has been read already. It's been read, but just the relevant lines, Malats, at 66 to 69.
66?
Yes, 60 to 69. These words are important. That's my third respectful submission.
That page?
Well, it's at page 60. This particular portion is which page?
8.
68. 68. You also use the first line.
Yes.
Please, you don't know the thing. If your Lordship has just the penultimate para at 68.
Yes.
This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. Third, penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments.
Well, Leonard Finn may read the 2 paragraphs above.
What peaceful
Two
means?
paragraphs
Peaceful
above.
from their side.
I beg your
They
pardon?
mean to say.
2 paragraphs above what my
From
Leonard
the
Finn.
ED side, not from your side. That is what probably.
I'll read whatever you want me to read, I'll read it, Bullet.
Not the relevant portion. Let him,
Yes,
They
yes.
have done it peacefully.
No,
let him read the 2
the
paragraphs.
previous
above.
para which he's asking
2 paragraphs
to
above.
face,
While Leonard
respond,
Finn may not
Mr.
do it
Raju,
peacefully.
please.
Let him read.
It is not denied by our.
Dictate Mr. Raju that what he should read.
We didn't interrupt once even, Malak.
Yes,
It took a long time.
please, Mr. Singh.
Mr. R2, Mr. Sibbal, has admitted that the CM was, the president of the party was there. So what is so great about this para? This para says that so and so time, so and so Miss MB took possession of the material, etc., etc. That's all. Nobody is denying that she was there. Now, these are derailment. I have a different point. I am saying that with this Panchnama, what you are projecting in the petition is either clearly false or your Panchnama is false. That's all I'm saying. This para is standalone, clear. Obstruction, could not do this, could not do a search, all wrong. Now, the fourth aspect is very important. My learned friend, I heard Mr. Mehta making what again is I can ascribe to mildly to wrong instructions. He said we informed them, and I believe I heard the word yesterday. The day before the event happened. I may have been wrong, I may not have heard you correctly, in which case I'm wrong. Well, it's the first and only intimation came from a casual email at.
Email can't be casual and non-casual. That's what the intimation was by email.
Have you heard my sentence fully? Have you heard my sentence? You realize. You don't be presumptuous, Mr. Mehta. You started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. You're only, that's why I say, obviously, if I'm searching his house and I send an email 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was beforehand informed. In the middle of the persons are there, some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email 11:30 for a search which starts at 6:30 is covering up his tracks, creating a paper trail to tell your lordship later on. My next point is, that the question he raised, I'm only answering that, but I'll have to put it down if necessary. I came there because a Z protectee, a Z class protectee, was informed in an FIR number 5 of 26 that unidentified persons who refused to identify themselves had entered this place and were dealing, and the Z class protectee had reached there. So naturally the police rushed there. That's all that happened. Now, Malats, the ED officials identified themselves much later. They did not identify themselves because the only identification would be a prior written intimation at 6:45 that I am Mr. A, Mr. B, Mr. C, we are going there at this time, or at least just before that. So, Malats, that is why I went there. That is nothing sinister about that. And whether she is a chief minister or a president of a party, she remains a Z plus protectee. So, Malats, the moment we come to know, we have to move. Well, in the light of this, your lordship may consider, I mean, I leave it to my lords, that we put in, if your lordship is so inclined, without notice also we can put in a reply saying these points. Otherwise, I leave it to my lords.
Otherwise, you will say 6:25 p.m., 11:30 p.m.
No, I will put in these things, your lordship wants me to put in.
Legal things should
So
be
there
done
are
in a
other
legal way.
respondents also.
Should be done in a legal way.
Anyway, I don't know. That's all I have to say.
Yes. Yes. You're for?
I'm appearing for respondents 4 and 5.
Sorry.
In first petition.
Yes,
Because we are yet to hear the second petition.
it's in both the
No, Mr. Raju wants to argue the second petition.
first petition.
First petition, respondent 4 and 5.
5, yeah. So I just have a very small point. Your lordships may just consider that the appropriate order perhaps in a case or a situation like this, your lordships have seen that the hearing which took place on the 14th was in a very orderly manner. So I would respectfully submit that that is the subject matter of a 226 petition. Let that matter proceed. The lordship wants to reinforce because the Chief Justice's directions are very clear. It's proceeding in an orderly manner. It ought not to be, that's my suggestion, that the 9th January disruption which took place when the court itself could not hear the matter, that shouldn't have a lingering effect which persuades this court to issue notice under 30. So let us see what happens, my lords, on the adjourned date or the next date as far as the 226 is concerned. If that proceeds smoothly, as it will, I mean, we expect that it will, that's a much better way of going about it, my lords, rather than this. I would respectfully submit that statement, at least at this point.
Yes, Mr. Raju.
There are several submissions that I have to make. The first submission is the recording of an FIR only requires that prima facie a cognizable offence is made out. If the averments in the petition make out a prima facie case that a cognizable offence has been made out, that's the end of the matter. Lalita Kumari is very clear. No inquiry is required, no accused is required to be heard. The defense is not to be
You
considered
are
at that.
speaking about which FIR?
I am asking for the FIR which I am asking to be registered and CBI investigation.
Oh, yes.
For that, I am making my submissions. So if my petition discloses a cognizable offence, then a FIR has to be registered. Nobody hears an accused before an FIR is registered is unheard of. We have made them respondents by way of abundant caution. That is what we have said without conceding the right. That is my petition says. I've said that in paragraph of my petition. I'll read that paragraph. This is one paragraph. Now, therefore, the issue that arises is, has a cognizable offence taken place? On admitted averments, the offence of cognizable offence has taken place because an offence of theft. I have pitched my case a little higher. It is not only theft, it is robbery and it is dacoity because more than 5 persons were there. Some policemen were armed and there was wrongful restraint. But forget that. Simple case of theft, which is a cognizable offence, is made out on admitted averments in my petition. If that is so, the issue is who should investigate. If a cognizable offence, FIR has to be registered. That's the settled law in Lalita Kumari. May I read Lalita Kumari or
Yes, read.
give me Lalita Kumari? Come to back. Kindly
You can continue.
I'll not take much time, but I'll only kindly have a look at para.
You argue, we have no difficulty.
Kindly have a look at para 120 onwards, conclusions.
Yes.
By
Para 5.
120
Para 120.
at page 61. 120.1. The registration of FIR is mandatory. Kindly note my mandatory under section 154 of the code. If information discloses commission of a cognizable offence and no preliminary inquiry is permitted in such a situation. So if the petition discloses a cognizable offence, it is mandatory that an FIR has to be registered.
Para 120.1.
Yes. I have demonstrated that a cognizable offence has taken place. One doesn't say that you have to inquire from the accused why you have committed the offence of theft. That is not the scope of registration of FIR. You have to look at the evidence made by the informant, in this case in the petition, and if it prima facie makes out a case of theft or a cognizable offence, FIR has to be registered. Therefore, whatever they are saying, we went there because of party document, which is wrong. Otherwise, no FIR would be registered. The entire purpose of the scheme of the CRPC would be frustrated. This is number one, Manoj. The second is, ordinarily, I have to go to the local area where the offence has been committed to get the FIR registered. But this case stands on a different footing. Your lordships have permitted deviations from the normal rule. Why the local police should not be permitted to investigate? Here, the chief minister is an accused. She is the person who has personally committed the theft. This theft was committed in the presence of the Director General of Police, who could be an abettor. It has been committed in the presence of the Police Commissioner of Calcutta, where the offence has taken place. So, head of the police in West Bengal is accomplice as far as the offence is concerned. Police Commissioner is an accomplice, and she is the Home Minister. So, no FIR, if it is registered, even if it is required to be registered, will be inquired and investigated properly. Now, the law is, kindly have a look at three judgments. In this case, if the highest authorities are involved, then the CBI investigation is to be ordered. But kindly have a look at, one is KV Rajendran versus Superintendent of Police, 2013-12 SCC 480. 480.
480. Para?
Era would be 17. Where they say if the
70.
17. It is extracted at page 31 of my petition, Manoj.
Page 31 of your petition.
Yes, of the first petition also, my lords, we can have a look at it.
Then
In view of the above,
page 480.
page 31 of my petition, my lords have got it.
481.
480 para 17, Manoj.
13, 12.
I can hand over a copy of syllabus.
No, we have
In view of
para 17.
7.
In view of the above.
In view of the above, the law can be summarized to the effect that the court should exercise its constitutional powers for transferring an investigation from the state investigating agency to any other independent investigating agency like the CBI only in rare and exceptional cases, such as where high officials of the state authorities are involved, or the accusation itself is against the top officials of the investigating agency, thereby allowing them to influence the investigation. And further, that is so necessary to do justice and instill confidence in the investigation, or where investigation is prima facie found to be taken. This is at the stage of investigation, but prior thereto also it can always be excised. Then kindly have a look at the second judgment, my lord, 2014, 8 SCC, page 682, para 86.
Oh, then 14.
2014, 8 in SCC, page 682.
Last but one page, just for easy reference. Last but third.
It is the para 86, Supreme Court page number is 736. It starts like the criminal justice system mandates that any investigation into the crime should be fair in accordance with law. So if it is investigated by the accused or somebody subordinate to the accused, it can never be fair.
Yes.
In accordance with law, and should not be tainted, it would be tainted. It is equally important that interested or influential persons are not able to misdirect or hijack the investigation, which would be the case if the local police are asked to investigate, so as to throttle a fair investigation, resulting in the offenders escaping the punitive course of law. These are important facets of rule of law. Breach of the rule of law, in our opinion, amounts to negation of the equality right under Article 15. Therefore, my lord, I can come here directly, because otherwise my right under Article 32, fundamental right under 14 would be infringed. Therefore, I can come directly to this honorable court, even under 32. No need for me to go before the High Court. Then, my lord,
Why can't you continue in the High Court?
I'll tell my lord why.
You answer it after we come back post lunch.
Very well, I'll answer.
And this remedial right is itself made a fundamental right by being included in Part 3. This court is thus constituted the protector and guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid upon, refuse to entertain applications seeking protection against infringement of such rights. No similar provision is to be found in the Constitution of United States, etc. Lord, here the officers are also before your lordship seeking their Article 21 rights, because there are FIRs filed by the local police, and they are threatened with, my lord, their freedom under Article 21. Apart from, my lord, my lord, jurisdiction, my lord, on behalf of the victims of money laundering, my learned friend.
Kindly have a look at Article 226, sub-article 4.
226.
226, sub-article 4. The power.
Yes.
The power conferred on a High Court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of under Article 32. So this, according to me, is the issue. 32 powers are protected even under 226, and as by the Senior Solicitor General had said, it itself is a fundamental right. There have been cases where your lordships have transferred investigation to the CBI and exercise the powers under Article 32. I may give one or two judgments by way of illustration. I see. Kindly have a look at para 80. And 82.
80.
80. This has been done in exercise of powers under 82. I may just leave it. But in a given case, your lordships may come to a conclusion that it warrants not only investigation by the CBI, but it warrants investigation to be done outside the state. In a given case, if it is to be done outside the state, 226 powers cannot be exercised. One judgment, my lord, to carry it. All that. I leave it to that extent. Therefore, now as far as the
Yes.
ED officials are concerned, my lord, 4 FIRs have been filed against them. Kindly have a look at section 67 of the Prevention of Money Laundering.
Which provision?
67. No suit
Yes.
shall be brought in any civil court to set aside, modify any proceedings or order made under this act, and no prosecution, suit or other proceedings shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. So the search proceedings were done under good faith under this act. Therefore, the prosecution, the FIRs are not maintainable. They're hit by the bar under 67. Despite that, to put pressure on us, these 4 proceedings have been filed. Therefore, I have read separately for stay. Order of stay may be passed, notice may be issued, and the matters may be heard. This is all that I was.
We are praying for stay of the FIR against us. The ED officials are facing FIR filed by the local police. My lord. These are, my lord, the FIRs. We have made, my lord, the averments, we have given the details, and we have prayed, my lord, in prayer F. My lord.
Yes.
And they are constantly filing new FIR. So that has been a pattern, we have seen. Lord, page 126 is the prayer clause.
Let us see the prayer. Prayer is.
Page 126. Page 126.
No.
E. Capital.
Main matter, page 46.
126. My lord. Main relief. Yes. Issue a writ of mandamus directing the. No, your lordship wants the entire prayer clause, my lord, to be read, or
Just a minute.
or the interim.
What are your, yes, interim.
Interim is page 126. My lord, where right now, my lord, I would be subject to your lordship, my lord, being persuaded, praying for E. In the meanwhile, your lordship gets direct stay of the FIR number so and so registered at Shakespeare Sarni, FIR number so and so, and any other FIR registered against any officer of the Enforcement Directorate with respect to the searches conducted on 8/1/26 during the course of investigation of coal scam, etc. So we have restricted our prayer, my lord, to this incident.
What is this past interim direction commanding the respondents to preserve, deposit, and provide a CCTV camera they store?
Yes, my lord, that should be preserved, my lord. Let it be with the registrar of this court.
No, right now you are praying for E only.
E. But my lord, if my lord, your lordships are persuaded, my lord, C also, my lord, A. Interim directions commanding the respondent to preserve, deposit and provide the CCTV cameras and storage devices containing the footage of both the premises search on 8/1/26 as described, and not to make any deletion.
Just take. In these 2 writ petitions referred by the Directorate of Enforcement. Oh, yes, okay, no. In the first writ petition, the petitioners are Directorate of Enforcement and its Deputy Director. Whereas in the second petition, the petitioners are
They're the assistant directors and the persons who were party to the search, and they've been named in the FIR as
the officers of the Enforcement
one is the
Directorate,
IO of the case.
Enforcement Directorate against whom
Nobody's named. I'm sorry, nobody's named.
huh?
No, they are not named, but they would be.
They went for the search, and the officers who conducted search without naming them are the FIR.
Who had gone to the premises, subject premises, in course of investigation conducted by the ED. Learned ESG, appearing for the petitioners, would draw our attention to the series of events which has led to the filing of the present writ petition. According to him, the ED was investigating a scam amounting to rupees 2,742.32 crores since the year 2020, and in course of the investigation of the said scam, intelligence was received that about 20 crore of proceeds of crime from Kolkata to Goa was transferred through R. Kantilal firm, and which has eventually channeled into IPAC's operational framework by being handed over to persons executing its work. Armed with authorization to carry out search and seizure proceedings at the residential premises of Mr. Prateek Jain of IPAC, the officers visited his premises on 8/1/2026. Visited his premises, amongst other premises, on 8/1/26. And when the search was going on, the Manoj Kumar Verma, IPS, the Commissioner of Police, Kolkata, first entered the premises. Dr. Sri Priyabrata, IPS, Deputy Commissioner of Police, Sri Manoj Kumar Verma, IPS, Commissioner of Police, Kolkata, entered the premises, and thereafter, the second respondent in WP number so and so, the sitting Honorable Chief Minister of West Bengal, Ms. Mamata Banerjee, also entered the premises despite making categorical request for not interfering with the ongoing search proceedings under PMLA. He would submit that this is not the singular incident where Honorable Chief Minister has entered the premises under investigation by the ED, under investigation, as on an earlier occasion when the CBI was investigating an offense, the similar event has happened. Therefore, there is a pattern of interference with the investigation carried on by the central agencies. According to him, the materials collected by the ED officers were taken away by the respondents in an illegal manner, and thereafter the West Bengal police have registered FIRs against the officers of the Enforcement Directorate. Full stop. Lord SJ would submit that in a situation like this, comma, it is difficult for the central agencies to carry on investigation which has connection with a huge scam running into so and so, 2,700 so and so crores. Full stop. Learned Counsel would submit that true it is that the petitioner ED has prepared a writ petition before the Calcutta High Court, but when the matter was to be taken up for a hearing on 9/1/2026, the legal cell of the Trinamool Congress sent message to its member on WhatsApp calling them to assemble in the court. And thereafter, what has happened in court has been recorded by the learned judge in its proceedings dated
Page 121.
121. Order is
dated 121, which is reproduced hereunder. Full stop. Para. On the above basis, Learned Counsel would submit that Learned SJ would submit, firstly, that the present is a serious matter which needs to be examined by this court, and secondly, the High Court is not allowed to proceed further. Full stop. According to him, comma, since high police officials of the state government are involved, comma, it would be appropriate for this court to examine the issue in the larger interest of justice and to set and full stop. Learned ASG Sri S.V. Raju, appearing for the petitioners in the other writ petition, would submit that recording of FIR in a cognizable offense is mandatory in view of the law laid down by this court in Lalita Kumari 2014 volume 2 SCC page 1. According to him, comma, when the Honorable Chief Minister and the Director General of Police are involved in the matter, comma, it cannot be expected that the police officers subordinate to them would conduct the investigation in a fair manner. He would submit that the present is a case where the offences committed by the respondents should be investigated by the CBI. He would next submit Sri Kapil Sibal, Learned Senior Counsel, appearing for the respondent number 2 in first writ petition, and Sri Abhisekman Singhvi, Learned Counsel, appearing for the respondent number 1 and 3.
Yeah.
1 and 3 would submit that the present petitions are not maintainable. He would submit that there is a pattern of interference by the ED in the name of investigation exactly at the time when elections are due. They would submit that when the matter is pending in the High Court, the present petition under Article 32 of the Constitution of India may not be entertained. Post op. Taking us to the materials on record, particularly the Panchanama available at page 66, it is pointed out that that nothing material was recovered during the search and the seizure. It is also argued that the local police officials were not informed by the ED before initiating the search in the morning of 8/1/2026. Sri Sibbal would particularly submit that the respondent number 2 had not gone to the place of incident in the capacity of the Chief Minister, but C, being the chairman of Trinamool Congress, had gone there on information that certain unauthorized persons have entered into the premises of Mr. Pratik Jain, who has been entrusted with party's election work. According to Mr. Sibbal, there was nothing available in the office of IPAC except some election-related documents with which ED has no concern, and they should not have entered the premises. The Sibbal would also submit that the respondent number 2, being the chairman of the TMC West Bengal, it's a national party, by TMC, is a jet protectee, is also a jet protectee. This is your argument. Mr. Singhvi will submit it. Singhvi would submit it. So it is a jet protectee. Therefore, it was the duty of the Director General of Police to accompany her when she entered the premises of Mr. Pratik Jain. Sri Shyam Diwan, learned senior counsel, appearing for so and so, or as one number 4 and 5, would argue that when the that it is factually correct that some untoward incident happened when the High Court proceeded to hear the matter on 9th January, but thereafter, on 14th January, the matter proceeded peacefully but has been adjourned at the request of the ED. Therefore, this court should wait for the outcome of the proceedings pending before the High Court. Having heard learned counsel for both the parties, we are of the prima facie view that the present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and its interference by state agencies. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that the offenders are not allowed to be protected by protected under the shield of law enforcing agencies of a particular state. Full stop. According to us, larger questions are involved, has been raised and are involved in the present matter, which, if allowed to remain undecided, would further worsen the situation, and there will be a situation of lawlessness prevailing in one or the other state, considering that different outfits are governing at different places. Full stop. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, the question arises as to whether in the shield of taking shield of its party activity, the agencies can be obstructed in carrying out their investigating power in a bona fide manner. Post up. Issue notice to the respondents. Let counter affidavit be filed within 3 days. Can you file it within 3 days?
Not possible.
Within a week. Within a week.
Give some time, at least 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we'll preserve all the material. If it takes longer time, because the digital
Not
evidence.
preserving, Maharaj, your losses make
Yes.
no issue on that.
Yes,
Uh,
in 2 weeks.
2 weeks.
Post the matter on. Today is 15. Post the matter on 3rd February.
Lord, prayer A and E.
Full stop. Full stop. In the meanwhile, it is directed that the respondents shall preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8/1/26 as described in the writ petition, and the CCTV cameras and storage devices containing the footage of nearby areas. Now, what it is to this investigation and the CCTV 8/1/26 full stop. It is also directed that the further proceedings and the investigation relating to FIR number 3/26, 4/26 and 5/26 registered at electronic.
There is one more, 7 also, Lord. I have placed on record.
It is there in the main petition, but not here.
In the additional document, it was filed
7/26 registered at electronic PS, Vidhan Nagar.
No, there are 2 from Shakespeare Sarni.
Just name the police station properly.
No, it's in E. E has, my lord, the police station. page 126E. 2 are, my lord, from Shakespeare's Sarni, and 2 are from electronic PS Bidhannagar. The index, my lord, in the present,
In just IA,
yes,
direct,
it's a document compilation.
is also direct that FIR number 3 of 26 and FIR number 4 of 26 registered at police station Shakespeare Sarani, and FIR number 5 of 26 and 7 of 26 registered at Electronics Complex PS shall remain state till the next date of hearing.
Or any other FIR pertaining to this?
So we may not be aware of.
This is
We
not
do
like
not
a
know.
blanket order.
There should be clarity in our order.
Yes,
You can't
sir.
say that any other, this
No, no, I understand.
is not proper.
Great.
Whereas I have one request, for you, just Lordship will consider it. Whereas normally a Lordship does not stay investigation. No coercive steps will be taken is an alternative.
No. You see, in view of section 67, if they were armed with a letter of authorization, they were acting in good faith.
So I'm only saying, well, investigation without any coercive steps.
Mr. Singhvi, you
No.
understand the delicacy of the matter.
But equally, well,
If you
delicacies on
proceed,
both sides.
if you proceed with the investigation in any manner,
Whereas
then
without
it will be
any
difficult,
coercive
but
steps.
then we will.
Without any coercive steps.
No, my lord,
In any manner.
that may not.
Secondly, Willis, if your Lordship is granting a stay on investigation, then let us have more time to reply, Willis, because then there will be a complete stay of investigation. Let us take out all.
No. 15
There has
days
to
is
be
enough.
more.
What more you want?
Willis, maybe 3
In
weeks
fact,
or
this
4
order could have been passed after 10 minutes of hearing. We indicated to you that we are inclined to issue notice. But since both the parties have raised that much of argument, it is necessary for us to record also.
Yes,
Because
be a little long.
Nowadays it is aired, everything.
Now
And
that
then
it is,
so everybody will say that court has
Now
not
that it is
recorded anything,
stayed,
so much was argued.
now that Lordship has stated, little more time can be given. That's
Yes, next case.
My lord, the IA for addition of party, but chief secretary and others are being joined. And my lord, prayer for
Chief Secretary.
suspension. No, suspension power is with the chief secretary.
That's suspension.
That's my prayer. That's my prayer.
We file a counter.
That's my prayer, my lord.
Let's
strongly opposing this kind of.
Notice may be issued.
let counter to IA number so and so
But yes,
may also be filed.
yes.
It's not even listed, Malad. It's not even listed.
No, it's given, my lord. Copy is given.
It's
There.
got-
I have tendered
These
it.
are the strange
You
procedure.
kindly list it tomorrow, my lord.
Whatever
Let
it
them
is,
file a
it's
reply.
not
I
even
may not get
listed.
the relief today.
That's not.
You only file counter. We are not saying anything. No passing
Yes.
no orders on that.
We'll file.
Passing no orders on that.
Malad, if we filing counters in applications, then the main matter, Malad,
There are only two main
There's
matters.
so many matters there.
No, only one matter in application.
Let's
That's all.
let counter to IA number so and so. Which are those IAs?
We'll give the number.
It's not
We
numbered.
file before the next date of hearing.
Yes.
Yes, next.
Item 28.
Ye
Oh, right.
हमारे notes का इस production है.
22.
Corrected.